When Jack Newton pinged me about doing a talk at Clio conference, I was really excited. I've known Jack for quite a while, the bald legal tech CEO. Stay together. And I started thinking, what should I talk about to the Clio audience? As I was thinking about that, the legal trends report was in the back of my head, and I started reading that, and the first thing that jumped out to me was this, which you guys have probably been getting hammered in for 2 days straight now, the sad reality of the amount of time lawyers are collecting on a daily basis, 1.5 hours of billable time. That's not good, and we got to fix that. But how are we going to fix that? Well, the one thing that I know that I think can be helpful to you guys is discovery, something I've been doing for over 16 years. So discovery is everywhere right now, all over the place. And when I say discovery, I don't mean e-discovery, I mean search. So discovery being the search for truth. So when I say discovery, just think search. It is all over the place. It's been in our elections. You might have heard a thing or two about emails in November. Well, this quote happened right up leading to the election when the FBI secured almost 1 million documents, and Trump went on stage and talked about how it was impossible to review this information in this amount of time because they had sifted through it in 8 days. And then General Flynn chimed in and said that would be a second per document. They're both not wrong. It's actually correct. If you were to read every single document over and over again, that's about how long it would take. But humans don't need to do that. That doesn't make any sense. Discovery is affecting the environment. This is a story about Earth Justice, and if you're not familiar with them, they're a fantastic organization. They have the enormous challenge of being the Earth's lawyer. Think about that. Pretty cool. They do some great work. And this is a story about how they leveraged modern discovery technology to protect Mexican gray wolves. This was a case that was going on for 4 decades, and then when they deployed modern discovery, they were able to sift through an enormous amount of information in a very short period of time, finding the relevant pieces of truth to get protection for these animals. Pretty awesome. It's in the front page news. This is the New York Times a couple of months ago. This is when you don't want to be in the news for discovery. This is really more e-discovery, which is discovery's evil twin sister. You don't want that. Not that at all. This is a law firm accidentally sending over 50,000 records of Wells Fargo's most wealthiest clients. Social security numbers, bank accounts, you name it, all because of a broken e-discovery process. So before I jump in further, I think it's helpful for you guys to know a little bit more about me and why I'm here. So I'm going to take you back almost 10 years. If you're having trouble figuring out which one is me, I've put a little pointer on there for you, a little more pixelated version of myself. That's my co-founder and I at our Inc. 500 party in Washington, D.C., where we founded the original version of the company. We had just landed on the Inc. 500. This was in 2008. We were the fastest growing legal services company in the country, which is what the Inc. 500 is. It's a list of the fastest growing private companies in the country. We're number 181 on the list, growing 1,200%, really fast, making millions of dollars in profit. It was awesome. This party was baller. We spent a lot of money on this party. We had a good time. But the day after this party, my co-founder and I got together and we started thinking about the future. Although we're smiling and having a good time here, we actually really didn't like what we were doing, and we definitely didn't like what we saw our future laying out for. It turns out, getting on that Inc. 500 list happened because we were working on behalf of these large banks and technology companies and these huge law firms, working on these enormous e-discovery projects, terabytes and terabytes of data, where they paid us millions of dollars for. And sometimes we would do things like document warfare, where we would dump an enormous amount of data onto these smaller adversaries. So we learned all the ins and outs of that. It was soul-crushing work. I've never been in investment banking, but I have a lot of friends there, and it sounds very similar. And that's not a life that I wanted to live. And that wasn't a problem I thought was worth us continuing to solve. So we decided, well, What would it look like if this problem that we were helping to solve wasn't millions of dollars and wasn't incredibly complex and slow? What would that look like? And can it be automated? And it turns out it can be. We are in a digital revolution right now, so a lot of software can impact the rest of the world. You've heard the quote from Mark Andreessen, software is eating the world. That's very true. And so we decided that, okay, if we can automate this, should we automate it? Are we the guys to do this? And we decided that that's what we wanted to do. So at the peak of our company's existence, we decided to destroy it. And for the next 4 years, we invested in building what would ultimately become Logikcull.com. I'm not here to talk about that. You guys can read about that online. And the other thing that we saw was this oncoming data tsunami. And you guys are seeing this now. Data is everywhere. But it wasn't always this way. In the first version of Discovery, we'll call it Discovery 1.0, it was mostly paper-based. Pretty simple stuff. You know, you would go to the filing cabinet to search for your records, right? You'd be lucky if some of those documents were scanned in and OCR'd where you could search them. But this is what Discovery was like for decades. Not that complicated. One 4-drawer cabinet, 10,000 pages, that's about 1/3 of a gigabyte. Then Discovery 2.0 happened. This is when email and electronic documents started to flourish. You guys all know about this. This was in the early 2000s. 1 gigabyte of data is now 30,000 pages, which sounds like a lot. This is where we are today. This is Discovery 3.0. The cloud has created an enormous amount of data. We create 2.5 exabytes of data per day. Look up how big that is on Google. It's absolutely enormous. The growth is exponential. The services available to you now are growing at a rapid rate. I heard in Cleo's talk about their Hermes app that they're creating, which is like a WhatsApp for lawyers, which is awesome. But that's also a way of communicating, which means there might be discovery of Cleo in the future. So you've got Gmail, you've got Slack, you've got Facebook at work. I just saw in the news today, Facebook just signed a deal with Walmart. Walmart is deploying Facebook at work. Walmart is the #1 employer in the world next to the DoD and the China's Republic Army. That's huge. So this is going to create a huge problem for discovery, but it's also an enormous opportunity for you guys, and I'll get into that in a second. So what does this mean for everybody at the Clio conference and all of Clio's customers? Well, let's take a step back. So in Discovery 1.0 and 2.0, this is what it looked like. And if you can't figure out which one's the small law firm, it's the guy in the white underwear, and the guy in the large red underwear is the AM Law 250. And they would crush these guys because they had the teams and they had the technology. They had people like me that they were spending a fortune with. And this was awesome for them. They could run circles around these smaller firms and drown them in data. I once met a guy at a conference in DC. He was at a small law firm in Florida. He spent 2 years looking for a dozen documents because he didn't have the means to search through this information. That's a problem. These guys had everything. They had the teams, they had millions of dollars in software, all this stuff that's installed and very complex to use that you need weeks or months or years of training on, and the small guy has nothing. Maybe Microsoft Outlook to do discovery, which, by the way, is not a good idea. Don't do that. Craig Ball, sitting up here in the front, has a great blog that you subscribe to learn all about e-discovery, by the way. So this is 1.0 and 2.0. The landscape has totally shifted. It's not leveled, it's 180. The small guy can now run circles around the big guy, and that's because of the cloud. You guys are going to be able to do this because the big guys overextended themselves. In the early 2000s, when e-discovery was all the rage, these big law firms invested heavily in managed services agreements, in complex on-premise technology, you name it. They've got it. They've got the teams, they've got the outsourced consultants, and it is a big sunk cost for them right now. This is a huge opportunity for you guys, because one thing that I know large law firms are reluctant to do is get into the cloud. I've talked to just about every single one of them in the AM Law 100, from the C-levels all the way down to paralegals and assistants. I've had conversations, and when you mention the word cloud, they run and hide inside of a corner. But that's not true for you guys. You're here at a cloud conference, and you could take advantage of this moment in time while they're starting, slowly adapting to change. So this is where you guys are today. The second opportunity that's in front of you guys is the e-discovery market. For those of you that don't know, the e-discovery market is enormous, and it's growing at 15% year over year, about $10 billion right now. It's huge. And you can see this in the chart. The biggest revenue is coming from services. That is your opportunity to disrupt. I used to be in that group of services. I know what they do. It's not that complicated anymore. In the past, it used to be incredibly complicated. So did generating electricity. Electricity used to be incredibly expensive. You have an electrical engineer in your house to run the lights in your house. That seems ridiculous this day and age, right? Well, that's true for discovery as well. The e-discovery services market there is about $8 billion. And for the vast majority of work that they do, it's a data in, data out. Now, that's oversimplifying it for a reason. There are cases that are incredibly complex where you need experts, but that is not the norm. For the most part, they're taking data and they're putting it into a searchable database so that legal teams can search, review, tag, redact, and share the information. That's basically it. And now you have technology that's available to you. So let me peel this back a little bit more. So this is how the current discovery process works. And this is even more an oversimplified version of this. It's a lot more chaotic and stressful than this. There's a lot of friction here. But this is how it generally works. And this is in the context of like a litigation or investigation. So the client sends data to the law firm. How they do that is all over the place. You might get emailed data. You might get FTP'd. You might actually get a DVD. You could even get a carrier pigeon. I don't know. Then the law firm will either do it internally and manage the data, which can be good or bad. But most often, they're going to send it to that $8 billion segment of the market, the e-discovery service providers, the quote-unquote experts. And then they process the data and they load it up for review. All this takes days and days of time. There's so much friction here. There are thousands of steps just to get emails into a database so that legal teams can review them. And when you take a step back, you think about that, that seems kind of ridiculous in this day and age. Well, one of the biggest risks here is data security. So as you see the quote from the SEC, data is most at risk when it's on the move. This is a huge problem for discovery because discovery is a process of motion. It defined is the free flow of information between parties. So it has to move, right? But it moves too many places. And this is creating a lot of issues for law firms and their clients. If you remember in that a New York Times article, that was a problem of data movement. The law firm sent a CD, a physical CD of electronic documents because of this process. This is broken. And this is the opportunity for small and mid-sized law firms to take advantage of. So remember that target? This is the target. You can disrupt this. These people here, for the most part, don't need to be handling that data anymore. This is a huge opportunity. So again, Wells Fargo, let me give you a little bit more context about this. This is how traditional e-discovery and discovery technologies work. Data goes from the client to the law firm to the vendor to whoever's requesting it. Well, in this case, 50,000 records containing highly sensitive information about Wells Fargo's most wealthy clients was accidentally sent to a guy who got it and said, that's not right. I'm going to go tell the New York Times about this. A little sketchy, but it got on the front page news. And you never want to be on the front page news for something like this. This is e-discovery. Don't do that. This is what is available to you today. Just like Clio isn't the only practice management software in the cloud, Logikcull is not the only discovery tool in the cloud. There are tons of them. Go to Gartner's Capterra online, and you'll see a ton of reviews of all these different products available to you. It's no longer scary to do this type of work. Data stays in one place, just like with Clio. You don't use multiple client practice management apps, you use one. And with Clio's partner network, you can bring in all the other tools to help your practice go even faster. But this is how it works in Discovery 3.0. Your clients can actually upload the data directly to you, which creates a much better and safer client experience. No emailing documents back and forth, no FTP. You can just invite them in, and boom, there you go. And then once the data's in, you can use these tools to slice and dice the data in very smart and fast ways, which is also a better client experience, because people don't want to pay for unnecessary work. And sadly, in the discovery world, a lot of money goes to unnecessary work, a lot of inefficiency. And then lastly, when you're ready to send this data out to people, don't ship it. You can use a service inside these apps. You can use Box. You can use, hell, you could even use Clio, and you can scale on demand. So, in the past, when you had, say, 100,000 emails to go through, which is not a lot of data these days, but if you had 100,000 emails to go through, using the math that I showed in the previous slides, that could take a long time, especially with a small legal team. But now with the internet, you can scale your workforce in real time. In seconds or minutes, you could have 100 people added to your firm, and then once that project's done, you just shut it down. That's huge. That's never happened before in the legal industry. So let's do some math. No lawyers like to do math, so we're going to do some quick math. All right, so let's imagine the impact to a law firm that starts to take on discovery. Now, if you're already doing discovery, awesome. You can always improve that process. If you're not doing discovery, maybe you should think about it. Discovery is not just litigation anymore. It's internal audits, it's due diligence, it's public records request, or FOIA, if you're familiar with that. It's all over the place. It's in the election. So 10 gigabytes of emails, a good proxy is 3,000 documents per gigabyte. If you want to know about the pages, it's about 10. That's based on over billions of documents uploaded into Logikcull over the past 4 years. And this remains true. So that's 30,000 documents, which sounds like a lot of documents to go through. But if you're using smarter filtering technology, you can get rid of the hay. Discovery is less about the needles and more about the hay, especially in this exponential data growth phase that we're in right now. The hay is only going to get larger and larger and larger and larger, and you need to have smart ways of moving that out of the way so that you can focus in on what matters. So it's not uncommon to see 95% cull rate. Out of all the data that's uploaded to my product, 90% of it never comes out. 90%, over 90%. So that means less than 10% is being deemed as responsive. So that leaves you with 1,500 documents. That's $9,000 billed to the client. So this is an interesting KPI that we're teaching our law firm customers about, because it's really hard to forecast revenue for the vast majority of law firms out there, because you bill on an unpredictable rate. The hours, how many hours is something going to take? What's the weather going to be like in 2 months? You don't know. So you got to get better with that, unless you're doing flat fees, which this actually creates a lot of interesting opportunity for law firms to bill on flat fees. If you look back to that old e-discovery process, the $10 billion market, it's expensive to do e-discovery in the old way. In the new way, that's less so. So how do you figure out your per document rate? Simple math. Take your hourly rate, your average hourly rate, so let's use $250 an hour, and divide that by 40. 40 is about the number of documents a human being can read, redact, and tag within an hour. Now, your results may vary. If you're dealing with more complicated content, that's naturally going to go down. Like if you're reviewing source code, as an example, or IP lawyer, or construction documents, maybe that's five documents an hour. Maybe it's 10. I don't know. But use 40. That's a good number to go off of. And then, boom, you have your $6 document. Why is that important? Well, now with modern tools, you actually can find out how many documents you're going to have to review. And you will have to review documents. That process hasn't yet been completely automated out of the way, and I don't think it will be for many years to come. So this is a good exercise to run. Or you could take this process, and 2.7 million seconds later, you reviewed all 30,000 documents, and you sent your client an invoice for, I don't know what that would be. You probably get this with an AM Law 250 firm. I once had a partner tell me he didn't want to deduplicate over 100 gigabytes of data because he wanted to make sure, absolutely sure, that everything was read. And my point to him was, that's the point. You dedupe, you move the duplicates to the side so you don't have to see the same thing over and over again. They said, no, don't trust that technology. So they ended up reviewing all 100 gigabytes of data. It took 3 months and cost their client millions and millions of dollars in fees. It makes no sense. So again, discovery is everywhere. When you think about discovery, just think about it as search. The world has completely gone digital. Law firms are no longer just dispensing legal advice. You are now a legal database. Everything is online, and everything is searchable. Let's take the case of public records. Public records are awesome and painful for state and local and federal agencies to go through because they're not at a stage in their development where they have the technology and the people to go through this information. They're actually kind of like the big law firms, and they're stuck. They're getting bombarded with public records requests, or FOIA, if you're familiar with that. And now the requests are not asking for paper records, they're asking for emails. It's not uncommon for your local government to take 4 weeks or 4 months or sometimes 4 years to comply with a public records request. And they might bill you for that. Like in Massachusetts, Boston as an example, they will charge their citizens for the time and materials for processing FOIA. Well, that is a big problem because that information is our information. We pay for that as the citizens of this country. And they're blocking that information because, not because they're trying to be bad, it's because their internal inefficiencies were terrible. It would take an average of 3 weeks to respond to a small public records request. Now they're doing them in days because they've adopted modern technology. All right, so I'm going to give you guys 3 tips. If you take away anything here, I think these will save you and your clients a lot of misery, and hopefully you don't get on the front page of the New York Times for all the wrong reasons. The first one is, when your client sends you data for discovery, just say no. Don't send it. Have them upload this data to a secure repository somewhere, and there's tons out there. Box is a really good one. ShareFile is a good one. I mean, Clio is a good one. I mean, there's a ton. And then the modern discovery products, they can actually upload directly there. Just say no. And let's say that doesn't work, and they're like, whatever, I know better, and they just send you the data. Don't open it. Don't do that. When you open your client's documents on your computer, you risk a lot of things. One, it's a stranger's closet of information, right? And you don't touch strangers' stuff. And they might have malware in those documents. They might have viruses. Who the hell knows what they might have in that information? You might alter the information, which could create spoliation claims on that data later on in court. You don't want that. Don't do that. Preserve the information. And this is one thing you can do to educate your clients on how to handle discovery data. Really important for litigation. So don't do that. The second one is, and this is kind of the tail end, we live in a world now where you can do almost everything on the internet. It's awesome. I live in the internet. I'm in San Francisco. It's great. When you're sending data and you're getting requested to send data on a physical media, CD, DVD, thumb drive, hard drive, whatever, just say no, don't do that. And you can use these examples of New York Times, sending out a CD of 50,000 documents as a bad way of shipping digital information. I mean, when you send emails, you don't print the email and put it into a FedEx envelope and then ship it out. Like, that doesn't make any sense. You wouldn't do that. You would share it versus shipping it. And this will save a ton of time. It creates better chain of custody and a better overall client experience. This is a big one. And that's not how the world works today. The majority of discovery is transmitted over physical media, even to this day. Lastly, thinking about the oncoming data tsunami, this is happening whether you like it or not. And this is a huge opportunity for the small and mid-sized law firm market to take advantage of it. You want to impact that 1.5 billable hours? Open your eyes to expanding your services to your clients and learning about new technologies. So embrace this, realize this opportunity is in front of you because it's a very small window of time. It will not always be this uneven playing field. Your larger adversaries will catch on. They will start leveraging the cloud maybe 20 years from now, based on my conversations. But they'll get there. So jump on that. Last thing I want to bring up is this. This is where we started. So how do we fix this? So discovery is one of them. Discovery is a critical piece of a lot of cases now. I've heard of discovery being involved in divorce cases where they had to search through a spouse's email and their Facebook records. That's discovery. It's just search. It's not litigation. Public records request. Every one of you probably knows somebody in your state and local government. And if you spent time with them and asked them, how are you handling your public records today? And what are you doing about the future of that? I would almost guarantee they kind of shrug. They don't know. And they're probably overwhelmed. It's really tough to go through all this information efficiently. So 1.5 hours of billable time captured. This is the 2016 report. I just saw the 2017 report. The numbers haven't moved all that much. This has increased by 6%, which is progress, which is awesome. But what if this happened? What if by 2020, the Legal Trends report finds out that the Clio customer base wakes up, starts leveraging this incredible partner network that's being built, and that 1.5 hours is increased by 166% to 4 hours, maybe 5 hours, maybe 6 hours. That would be great. But the only way that that's going to happen is if everybody who has clients thinks about how to create a better client experience. Because cash is great, but in order to get cash, you need to have a great client experience. I read more in the Trends report about where attorneys are spending their 8 hours of time, and almost 50% of it is in administrative, tedious tasks. So take a step back, take a day, take 2 days, and think about what can be automated. Are you doing things that are repetitive that could be automated with technology? And your results may shock you, because that's what you're gonna save time. And then the other question they asked is, what would you do if you had more time? And the vast majority of people said, well, we would do more networking. We would try and get more clients. That sounds great. I'm all for that. But you're in a period of time where that might not help you move the needle, because client development is a lot of time spent in doing that, a lot of money. Well, what if you learned about new services, discovery being one of them, and you became an expert at that so that you can add more value to your client and you create a better client experience? Well, this is where we could get to, and I would love to see that. That would be really cool. So that's it. That's the rest of my talk. This is my contact information if you guys have any questions. We launched an integration with Clio. You can read more about that at logikcull.com/Clio. And that's my Twitter at IDDo. I'll be around for other questions.